taxable. Yeah.
Now, here's some people. There's been people that have probably maybe in here that's familiar with bankruptcy. I won't name no names, so that's up to them. But publication 908. Yeah, this is it. This would be an interesting read. Do you know if you file bankruptcy that the obligor or the trustee is supposed to get an EIN for the case? Let's just say that it's an individual, so John Henry Doe. So you basically would go get an EIN, John Henry Doe Bankrupt Estate, and that would be the name of the bankrupt entity. And it says in the form that you're supposed to do that. And at the close of the case, now I'm not going to say, does that mean once the ruling has been done, or does that mean once all the payments have been satisfied? I ain't got that answer yet, but you're supposed to be able to file taxes on that estate for a recoupment. And I said, wait a minute here. Then that tells me exactly what the attorneys are doing. The attorneys are not telling you this. They're going and getting the EIN. And then once a certain amount of years have passed after the closing of the case, they're going and filing a 1099-A claiming that account as abandoned. I said, boy, that just is a slap in the face, ain't it?
Yeah, I think I remember reading somewhere that it said that Donald Trump actually did that.
It's good business, honestly, because if people aren't taking care and satisfying their chattel paper, someone has to.
Yeah, I mean, look, they developed this system that if people don't care to learn and you want to abandon your wealth and give it to them,
you
have the right to do that.
Yep, you can. Absolutely. And it's just, it's inherited. It's passed on, from the father usually, this knowledge. And so many of us didn't get it from our fathers. And just imagine if you were, 15 years old and your father was sitting you down saying, son, this is how it works. So many people abandon because they're not awake. And I want you to be awake. Take a look at this.
Yeah, we were nurtured by our mothers through the patriarchal language, and our father was absent, so to speak.
Well, that's one way of looking at it. But see, in my case, my dad, growing up above the top of his desk on his bookshelf, he had all of Title 26. He had studied all of Title 26. He had it in hard copy and read all the court cases and everything. He knew tax law.
That's pretty cool.
And he tried to teach me this stuff growing up. But me, I was young, dumb, and naive and thought I knew better. So I just did what I wanted.
Didn't we all?
No, and now I look back. I actually had to come back to my dad as I got older and said, Dad, I now see everything he was telling me, and I owe you a big apology because you tried to warn me. You tried to tell me. I didn't want to hear it.
Yeah, good for you. You should make amends like that because...
Oh, shoot. He's my best friend now. One of my best friends.
It's so important to make those connections that, that you just didn't have the eyes to see. And that's all there is to it. You just didn't have the eyes to see. And it's a blessing that you do today.
And that's also why I say it's not fraud. If you voluntarily are going to waive your rights, because they can't take anything, you have to waive them.
There are soldiers. There are soldiers that they don't want to be in charge of nothing. They're they're shitbirds. They don't want to do nothing. They just want everything provided. They just everything. Like they don't want to think about nothing. Yeah.
Volunteered servitude.
That's it.
Why do you think the elite call the masses useless eaters?
Vulgar, disgusting public.
I just had a discussion this morning. I said, I can actually understand, and I hate to say it, but I can understand why the elite think like they do, because we were talking about the COVID jab. I said, if you really look at what the elite talk about in their writings, go all the way back to eugenics.
Yeah.
I said, they really do see the masses that don't care, that just follow along as useless eaters. And yeah, they want to wipe those people out because they're a detriment to the society, because all they do is go out and create public debt.
Yeah. Consumers.
That's
And,
it.
and that's why their whole system is based on insurance, of risk management, of waste management.
Yeah. And I hate to say it. But you kind of have to. You get judged by your own actions. I mean, we all are one day going to face the Creator. Are you going to answer to the Creator for what your neighbor did? No, you're going to answer for what you did.
That's why, the consumerism had to be capitalized, so it'd give these people incentive to volunteer to be a public servant, to do something with these beasts of burden that are just being consumers, wastefulness, lawlessness.
Yeah. That's also why I say that there's a certain level of responsibility when you become aware of learning this information. Some people, if they ever got to the point where they understood this system well enough to actually navigate the system, some people would abuse it. They would go sit at home and watch the country burn, because why? They wouldn't be a productive member of society.
And that's where
it's a powerful tool. That's all it is. It's a powerful tool. Money is a very, very powerful tool. And like I've made this comment before about that guy that bought all the soccer balls, in Africa when he was visiting, and most of those kids got murdered on their way home for a soccer ball. Just because you're rich and you're throwing around money, and you buy a kid a soccer ball and you think you're doing him a favor, and you don't realize that he's going to be murdered and cut up with a machete before he makes it home with that ball. Money is powerful.
Because the stronger people didn't have the ball and they wanted it.
Yep, exactly. Yep, and you gave it to a weak person. You gave it to a person that could not defend it. Had no right to hold that. That's like a grenade. It's just you shouldn't have done it.
Agreed.
Shouldn't have done it.
And that's where most of these. I'm sorry. Go ahead.
You got to take in consideration so much when you're abroad and you're traveling and you're experiencing other customs. You have to be very careful with throwing your customs around. It's very detrimental.
Consideration and concern is just like accommodation. According to satisfaction. And I think most of the time the conversations we have is what that responsibility is and where it lies, that you mentioned earlier. What I deem as that responsibility and where it lies is a little bit different than what Eric's is, and a little bit different than what Pastor's, even though you two's are similar. That's what we always discuss, is what that responsibility is and where it lies. I think is what we have conversations about.
Yeah, I mean, I know that having the knowledge I have certain responsibilities. That's why I am not one of those people that will give you a template. Because I don't like a lot of the template gurus out there. Oh, do my process, do this. Because why? They never teach you how to defend it if you get drawn into court. And then you end up going to jail, and the government loves that, because then you'll get out and say, oh, this is just fake, and you'll keep the other slaves on the plantation. So if you don't study to show thyself approved, and then you have to go defend the paperwork and you can't, whose fault is that? Is it the guru that gave you the template, or is it yours because you didn't study before you even filed it? See, majority of the people, they just want a quick process. Fix my problem. They don't never really want to study. And those that actually are serious about it are going to read the information so they can get to the point where they can stand on their own 2 feet. That's why I teach like I do. I want you to get to where you can stand on your own, because I would really hate to have to go to sleep at night knowing that I provided you with a template that you couldn't defend and you ended up going to jail or losing your home or something like that. That's why I won't do it. But if I'm going to do something for you, I'm going to teach you why. I'm going to teach you, I'm going to give you the information so you can learn it.
And the something I was really thinking about when you were talking to that young man today, I was just thinking style. This is about style. This is why I really push style. Everybody learns how to surf. Everybody gets up. But about style, and the reason why style is so important is because when you do make a mistake, you do want to be afforded equity. And so therefore you want to bring equity. And a part of bringing equity is in your style. And I think that's really important.
Yeah, go look up the word mistake and go look up the word error. A mistake can be fixed. Error cannot.
Yeah, I take style over
UCC 1-103.
I take style over a method or process any day, Eric.
Absolutely. Style's where it's at. And this is why the prayer is a style. Prayer is a style, and the way you come across in a prayer is very soft and kind, and that style is very equitable if you ever need it.
Hey,
that's what,
being a gentleman always works. When I had that mud flap ticket I was talking about, one of the things when I went to trial is when I switched my arguments from constitutional arguments over to contract law, I didn't say contract law. I just used the proper language.
Yeah.
Like, how are you going to hold me liable to something I had no knowledge of? That's contract law. I looked at the judge. I looked at the judge and said, hey, when the officer pulled me over and told me I didn't have a mud flap, I thanked him. I said, I didn't even know it was gone. He looked at the officer and said, is that true? And the officer said, actually, surprisingly, yes, he did do that.
I love that. I love that case, man.
Yeah. He said he just thought that was something surprising because I didn't argue. I treated the officer as a gentleman. And a gentleman,
style, brother.
They're going to treat you differently. That's
the style. Exactly. Yeah, that's the style. And then when you develop a style like that, and you develop it not just in your writing, but in your, in your day-to-day, it helps so much. People go out of their way. People go out of their way.
Hey, Eric, I can attest to that. After having to go to the courthouse and to deal with the judge. So he just basically wanted to meet me. He wanted me to go up there, talk to him. And then when I stopped arguing and I agreed to enter into a plea of no contest, he basically paid for it all. And he took me out in the hallway and told me that he was here for the common man, which he was saying that this was his way of extending equity. He basically let me appoint him fiduciary and told me that he could protect me in his courtroom.
Wow.
Awesome.
Yep. He accepted my oath of office and everything.
Sure, man. Fiduciary responsibility. Yeah, I use the word fiduciary because it's so powerful.
That right there proves what I say. when you know your rights and you give the judge what he needs to defend your rights,
Yep.
normally they will.
Now, Jesse, your reputation will precede yourself, and you will overcome all the rumors of that's gossip and summarized recorded on the record. Those are all overcome. Now your reputation will precede yourself.
Yeah, it was pretty awesome. I called him back.
It
yesterday.
is. It's awesome when you see equity work. It's different in all the cases, and that's why it's hard for people to comprehend or hard for people to teach, because it happens differently. Every case is on the whim, on the man, and
why
men are different.
Why? You know why? Yeah, that's exactly why. You are not going to be in front of the same judge.
Nope.
You are dealing with a different man or a different woman, depending on where you live.
Yep.
And it is, you got to know how to articulate yourself according to each man or woman you approach.
And he could be a bass fisherman.
Now, I just got a message.
What's that, brother?
So it actually says that we're the grant. No, it does not say you're the grantor of the trust.
Could I ask you a question real quick?
Yeah.
Did Jesse say he entered a plea and no contest? Because to my knowledge, that goes down as a conviction for them.
Who's getting the conviction? The trust is, not Jesse.
The goat.
Jesse did. Jesse did plead no lo contendere.
The goat.
Trust.
Yeah, that's all part of the
goat.
conviction, right? I see what you're saying. The trust absorbed it, what you're saying.
The straw man, the Social Security trust account. Now, I want to address this. So it actually says that we're the grantor of the trust, our mother is the grantor. It does not say our mother, but technically we are. No, that is incorrect. If you sign away your property interest to anything, to another, does it not become the property of the other person? Yes. Guess what happens then? They become the owner of it. They can do what they want with it. That's why when you sign the contracts, before the birth event even happened, you gave an assignment to the state for care of the infant. The state becomes the grantor of the infant because it's a decedent. It died. It's the placenta. It's not you. That's the thing people are missing. They keep thinking that's my name, that's me, that's this. No, it's not. You don't even have any firsthand knowledge that's your name. All you have is hearsay.
Start there. Yeah, thank you, Pastor. Start there. You cannot testify. Period.
And that's truly admitting your state of mind. Is your mind sound enough to hear it, to know fiction when you hear it, to know gossip and rumor when you hear it, or not?
Well, doesn't the Bible says thou shalt not lie? That means you can only tell the truth to something you have knowledge of your own self.
And that
you do not have knowledge of yourself. That's your name. It was told to you, or you read it all your life.
And that's observable. If I observe, yeah, that is hearsay. But if I observe something in my life, I am have firsthand knowledge. I have firsthand observable knowledge. Now, when I reiterate that, or quote, publicly regurgitate that, divulgate that, that might be a problem because I might not remember so well, and someone else that witnessed it will have a different opinion of it. That's the problem with firsthand witnesses. They're not so reliable because of that reason right there. I got to be very careful when I speak in public or I publish something that I'm not moving into hearsay and gossip, because I better be able to stand on what I observed.
Better get that double authentication.
Well, authentication really is not 100% what people make it out to be.
And can't I just make a funny and you laugh, for God's sake?
I
Yes,
did.
you can.
I'm
I
at the
think the
state.
oh
I'm laughing. That was
um,
funny. That was really funny.
yeah, I got somebody there in class right now. They're not in the live, but they sent me a message on that, so they're not in here to hear it. A lot of people they really do have a problem with the name, and yeah, why? We love our moms. I mean, yeah, our mom named us, and we want to say, yeah, that's our name, but we've never taken control of the name. We've never done what we needed to do to prove to the state that's us. That's why as soon as I got time and I can go home, I'm going to go get my TIN, because why? Now I can show a separation between that entity and me.
Is the TIN your estate EIN? Can you elaborate on that, Pastor?
No, it's not. What have you heard me say? You've never declared who you are. Supreme Court says you have the right to declare who you are at any time. Well, if you have no documentation as your evidence of who you are, the government don't know who you are. So what do? You start establishing a record.
Called the Who Are You? Who?
I don't know about you, but I don't think your feet fit no limb.
He says in that song, the last thing I remember is sitting around and throwing from my chair.
A lot of people have this thing, if I just put an affidavit into court, that's going to do it. Well, yeah, an affidavit is one thing, but if you have no supporting evidence to establish your facts, then all you're doing is making mere allegations, and you hope the judge laughs you out of court, because a lot of times you'll get in trouble doing that stuff if you don't do it right. Now, the authentication of the birth certificate thing is, all you're doing is authenticating a state agency. You're not even authenticating you.
I'm talking about the notary seal on the affidavit.
Well, that depends. Do what, Gwen?
I was just saying, I like your teaching on the birth certificate, making that registered date, the date of birth of the name on the certificate, and go and do the actual birth of the baby in the court records, the way that you teach. And I thank you for sharing that. It's registering with me now. Not registering, resonating.
Yeah. I mean, it's the Kentucky court, according to KW, they admitted in his case that it's a state agency. Well, if it's a state agency, when was it created? That was the file date. And Dee was actually talking to me on what she found out. Said you can't even use firsthand knowledge to correct that information. All they want on that information is hearsay. She said she went to both the state of Texas and the state of Georgia, because she was born in Texas, her daughter was born in Georgia, and they said, we can't do anything unless you go to the court and get it changed. Oh, so you want hearsay, you don't want firsthand knowledge. And she also got it confirmed that BC that they hold in their possession is definitely not you.
That's because they're going by a decedent will, the will of the state that controls decedent affairs, and they can't take the will of a man standing in front of them over that, because the whole system's based on that. You have to overcome that result.
Yeah, I mean, that's why you have to establish who you are. Now, there's some people out there teaching, I should never have to do business with the government. Really? Who established government? The Bible says God did to do what? Punish the wicked. Well, so why shouldn't you notify the government as to who you are? Because they're going to make presumptions about who they think you are, and they're going to define you according to their terms if you don't know who you are. So what do you got to do? You got to start figuring out who you are and learn how to rebut their presumptions and start acting accordingly.
Tell you everything's summary, right on its face, summary declaration. So they're summarizing your past inequities. When you see one and same person, I know we talked about this, Pastor, but it says in there past, present, and future. So they're recording your past and present activity to assay marketable future activity of your split double-mindedness of unsound mind. So
Well,
go ahead.
Here's one for you, Bobby. I don't know if you have, but there's been people out there that's dealt with family court and like neglect charges, stuff like that. And one of the terms that will always come up is that the party is not a prudent mother or a prudent father, and because of that, they were neglectful, right? Do you know the one word they've never defined in law anywhere? The word prudent. I decided to go to etymology.com and look that up.
It's a
And
good
the
one.
reason why
It's a good
the
one.
reason why I bring this up is because of what you just said. When you go to etymoline.com and look up the etymology, one of the things that the word prudent means is the ability to foretell or foresee. In other words, fortune teller, you're supposed to be able to predict the future. I said, tell me that word prudent isn't subjective.
Okay, now hold on a second. Let's stay right there for a second. Now, I can predict my future behavior. No one else can. I get a choice of how I'm going to react to all of this world things and natural world. So to me, that's what it's saying. I've got a soothsayer. I've got a right in full alignment with my creator, whoever personally deemed that is, to assess my future activity, not anybody else. So if, like the Beatles told us, Dear Prudence in their song, they're speaking about and singing about the prudency of me, of not only my womanhood, but also my manhood within me, of joining them two together without barring, latching, or grooving, and locking myself up tight like that. That's what I hear you say when you just said that.
Yeah.
It's sagaciousness.
I find it interesting when you said my womanhood and manhood. I said, because I tell people sometimes everybody has a masculine and feminine side. The masculine side is logical, the feminine is emotional. And I've told people before,
Absolutely.
quit. I told one guy, he fell in love with my daughter and they broke up and he got all emotional over it and he still ain't right. I told him one day, I said, man, you need to put your mangina away and start acting like a man. I said, he started, what do you mean? I said, well, you're acting like a woman. You're all in your emotions and you're not acting like a man.
Well, when we were talking to prosperity earlier, he kept saying, I don't like, I like. Well, that goes back to accord and satisfaction and concern and accommodation. Now, I don't like a lot of things, but I put that like where it belongs. And when it comes to talking to you and other people, the likes don't concern me very much. It's what we are talking about in context, and I don't fall for the man baby childlike wants and wishes and desires of children in those emotional states anymore, right? So,
Yeah.
so the likes really, it has no bearing in the case. It doesn't matter what you like at the moment. We're talking about what behavior you're putting forward. What is your style today? What is your style that you're telling me that goes with all the other recordings of your styles in the past? It's different today. Why is it different today? You have to explain that to them why it's different today than the past that they have recorded of you. Does that make sense?
Yeah. Now, ladies, don't take what I said as an insult or anything, because God made y'all to be emotional. Because I'll tell you now, if it wasn't for y'all, we would struggle on the emotional side. Y'all are supposed to complete us.
That's why equity is supposed to provide for the women and children, because of that reason right there. They're exempted because of that reason.
Yeah. I married my best friend. I mean, I'll tell you that now.
But
We don't
not
always
men.
get along, but I'd be lost without her.
But not men who act like women who are enfranchised, who are in fellowship, you will, being fellows, being gantry up in that system and acting all emotional, if that makes sense.
Yeah.
You realize women have logic also and emotion.
That's
Everyone
right.
is stuck with books. So we don't take offense to that. We just understand better how to handle things because we're so emotional.
Right. So
Yeah.
if women act in manhood, like a man can act in womanhood, that's voluntary servitude to some sort of implied contraction of an agreement of a minor state of mind. So women can act in manhood and venue themselves right in there too, and they won't get that protection from the equity from women as women and children because they
Well,
start talking just like men do.
well, God designed us a certain way to actually fit together and complement each other. Okay, so yes, both parties do have both natures to a certain level, but men are more masculine, and y'all teach us the feminine, and that's what makes us strive to be better men. At least that's what it's supposed to be. Unfortunately, society has got everything twisted upside down to where now men are confused and thinking they're women.
And the song, just the two of us, we can make it. If these songs are telling us, they're not. That man is not singing about another woman. Physically, he is, but metaphorically, he's singing to his womanhood. That if he gets it together, he can make it. If he just tries, he's never tried before. Now he's going to try. All these songs, all these broadcasts on TV, broadcasts on radio, telegraphs, telephone, telephonomic. They're telling us from a distance how they're weighing us or how they're speaking to us. It's everywhere. Once you see it, you can't unsee it.
Tell live vision. It's television. Television programming. That talks about we're not fighting against people, we're fighting against principalities and powers of the air. Ain't it amazing how the media comes through the air and this is Satan's world?
I got one better for you here, Pastor. When we all go out there, what are we doing? We're expiring. We're putting off fares. So that's what they're controlling. What is our style of putting off fares? Is it of arrogant fashion? Are they looking at how we dress, how we redress and address other men? How are we
Yep.
clothing other men? Are we reclothing ourselves because we're trying to be in disguise and our clothing of our father, or literally our born day suit, isn't good enough and we have to fall for a birthing day suit to be David to this Admiralty maritime thing?
The abortion debate, when the Supreme Court ruled on abortion, yeah, their ruling was accurate. It is a states' right issue. But don't you think in 1973 they knew that? When I read that 72-page document from the CDC that lists the products of conception and how it's all three are to be registered, yeah, it actually can be all three. JW brought that to my attention, and talking to Dee the other day, she actually said that the lady at the neonatal hospital even told her there's 3 certificates filed, 2 births and 1 death. But what it really showed me was when the abortion happened, because all the products of conception were abandoned at that point, the state would register those babies to create more trust accounts so they could trade more securities in U.S. obligations. And I said, wait a minute here. Maybe they overturned Roe versus Wade wasn't as benign as it sounded, even though, yes, they're right, it's a state's issue. but maybe because they're changing the monetary system, they
Yeah,
no longer need the trust accounts.
I agree. I think so too. And I think it's a returning of equity to the people, because when I hear you say states in this context, I realize that's a legal context of monetization, securitization. But if you look at the word state and property, it's states and conditions of the mind. So they had to arrest the people's minds in the 70s to quit the multiplication of being, so to speak, till they could manage these properly. And these people weren't just going forth for go forth and prosper type of thing. These people were just had unlimited amounts of kids, those kind of things. So as they give that abortion rights back to the states of the people, it's these people, these women literally have the right to make that decision between them and their creator, and no other man, not even the husband. I mean, she can consider that, but it's her body to perform the laboring, L-A-B-O-U-R, the labor, to her creator and for her creator of that creation. So
Yeah,
if
but that can be debated from two different sides. If you're
it can,
doing it from God's side, then your argument would be incorrect, because technically the child would be the father's seed, the father's offspring. But if you
well,
look at, but let's look at where rights come from. That where rights come from a God, right? Or the creator. So what has government done? Now, government has turned that on its head and said, we give you these rights. We call them civil rights. So what has happened? The people have turned government into God and says, I want government to give me these rights.
okay,
So
can
we
we stay
went,
right there?
so yeah,
Okay,
go ahead.
can we stay right there for a second? Okay, the first part is I agree with you, except the part that where the man and the woman come together, but without the divine spark, there's nothing. That's why they give us the story of the Mary, the marring of man, because it's the rubbing down of his sound of mind. So when you, this is the way I interpret it. So when you look at that whole story, that narrative that they give us, they are telling us that the Immaculate Conception is of man's impregnating thoughts that he has and drifting. If he's not of sound of mind, he's going to be moved in such a way of that childlike state of mind. So, really, like I said, it's between the woman and her creator, because it is a divine spark given, and the man and the woman are just those material, physical, through carnal knowledges of that physical lusting thing, of the seven deadly sins versus the seven virtues. Now, when we flip it over to the legal side, it comes into a conception state that, yeah, it is physically the man and woman being there, but they never acknowledge the man. They always do a matriarchal thing and register in the event as a birthing, BERTHT, in the time law, and never recognize the father because they want to be that sovereign citizen, patriarch. I'm saying that
Well,
backwards.
the state wants to be the husband.
Right,
I mean,
right.
I was telling somebody the other day, go
And the
back to the
father.
go back to the Garden of Eden. When you look in, when Eve took of the fruit, what was Adam doing?
Well, he was drifting
Watching.
in his mind.
He was
watching,
watching. Yeah.
Yep.
Well,
Yep,
what
yep.
happens at birth? Eve is still partaking of the fruit. She is filling out the documents. What is Adam doing? Watching. The serpent or the doctor is the one taking, cutting the cord, taking the infant, the documents.
Circumcision.
The man is watching. Same thing.
So the watching goes back to the seeing and becoming aware of the observable proof. Okay, the perception of a mentality and understanding what's going on. It's a visiting a place it's to inspect. Okay, but it's also while you're doing that, this is the automated and the artificial intelligence I talked about earlier. If you're not aware of what you're doing, you fall through these generational indoctrinations of this robotic behavior that you don't know you're doing. So
Yeah.
the C is the seat of a bishop, a throne of a bishop, an archbishop, or a pope. So as we're seating this in our mind, we are filling that chair. Okay, we're becoming statuesque in that thought process. And most of us stay there because we don't know we're doing this automatically.
Yeah, no, it's just, I mean, we go to the hospital, we trust the doctor, we don't realize what they're doing with the paperwork and the infant. That since we're just sitting by watching, just like Adam did, we are giving up our rights and giving that infant over to the state, which means now they create the trust, and we know the rest of the story.
Giving away divine natural rights and actually accepting suretyship of civil consumerly protected rights that we don't even know that those rights are protected by consumerism half the time.
Yeah, but look, they even go a step further. What did they do? They put an announcement in the paper. Well, I tell
Right.
people, it says, how did you claim property back in the day? You put an announcement in the legal section and run it for 30 days.
And get this, they used to go down to the city post in the middle of town, the post, and pin it on the post so everybody could read it when they come to town.
And they even gave you the time frame to claim the property in the newspaper, and nobody ever claims the property.
Funny how some of these people, the nosy people, my aunt used to do this, and it's funny because she was a really staunch capitalist and wanted to be in the know, and there was societies in town, that kind of thing. But she'd always read the public notices, so she had that gossip. Oh, so and so filed bankruptcy. Oh, so and so had a marriage. Oh, so and so had a baby. And I always thought that was weird and funny. But if I knew then what I know now, that was put in my life to take notice to that, so I could figure out what was going on. But I just brushed it off as a nuance, right?
Yeah, back then, before we learned this stuff, we didn't know any better. I mean, we were in our infancy. We didn't know.
I think those are moments of clarity, like an alcoholic does in the 12-step programs, and people do with addictive interventions. We have these moments of clarities, but we brush them off because we're so fucking busy doing survival, fight, and flight of animalistic behavior. We just don't take time.
That's right. We don't. Let's see here. I need to connect Bluetooth. So, well, I hope you feel better, Bobby. I knew sooner or later I would talk to you. I was just a little bothered the other day, and I would rather not say anything at that moment, you know?
Oh, thank you. I appreciated it. I knew we always agreed more than we disagreed. It was just getting lost in translation somewhere. And, obviously we still don't agree about some things, and that's okay too. I mean, I like to have these kind of commercial conversations because I like to know how people are doing things, and I like to help people on their level. And when they hit me in private and say, I got this problem, I like to know how to explain that. And you guys help me explain that through contracting because they're stuck in a fucking contract. I stress the word fucking because somebody's fucking others. So I can have these conversations and keep them in context. And I hear what you're saying about disrupting that conversation if it's in that context. So I took notice of that, and I understand what you're saying. So if we're having a commercial contract or discussion, I can stick with that. I'll do that for you, and I'll keep that in mind specifically when we're talking. I appreciate that.
Well, the reason I teach the way I teach is in the back of my mind, I've always held to this thought of remembering where I came from. And when I started my group, I had somebody actually, why are you starting another group? Ain't we got enough? I said, no. And what made me start it was these single process groups, right? In other words, only talk about this in here. Don't talk about nothing else, right? And I said, wait a minute here. I said, did y'all forget that at one time y'all didn't know anything either? And that these people that are coming here new have logical questions that they just want answers to? So I started my group for people that are somewhat new, that have questions. Bring your questions. You're seeking answers. I'm not going to turn you away because you only want to talk about one process. No.
Yeah, that's great. That's great. That's great.
we were there at one time. Look, you were there at one time. You didn't know none of this stuff.
Absolutely.
We tend to get so caught up in the knowledge that we have gained, we forget how to talk to the people that are new.
Yep. Yeah. It happens very easy too. It's not an easy thing to have if a man's coming to you and he's talking and you can hear him moving in and out of context, is what I call it, of his spiritual standing to his legal standing, let's say, or legal status. If he's moving in and out of context with different words and terms, I can hear that. So when he asks me a specific question, I try to answer the specific question, but sometimes one, he may not understand it. Two, it may went over his head. Or three, gets triggered because he doesn't have listening comprehension to hear what I just said. So I have to backtrack, and especially if he says it in paragraph form, what part do you want me to answer here? Because I hear all these different things that you're saying. So when I go to the definitions, I try to narrow it down so I can answer his questions specifically, but sometimes that don't even go very well. So it's tough. It's tough to have conversations in Babylonian fork-tongue languages.
Yeah, but we can't bring people out, so to speak, until they acquire the knowledge to be able to stand on it.
That's true. That's so true. It's just how to get there. It's the in between. We're always living in them in between states, aren't we? It's hard to get out of the cut, so to speak. Even in language, it's hard to get out of that cut.
Mm-hmm.
Pastor,
Yes. Yes, ma'am.
did you see my message earlier?
About the BC?
Yeah.
Authentication, it's really one of those things. It's hit or miss. You can do it if you want. You don't have to. The only thing that's really good about authentication is you're asking the court to accept it as according to the rules of evidence. Because why? What is
Okay.
it?
It's very interesting because
it's double hearsay without it. And the authentication process takes the double hearsay off of it.
Okay. It's
Now
very interesting because in Indiana, you have to order a long form birth certificate, but what I have in my hand is actually, it says certificate of live birth, and it actually says child, name, first, middle, last, and it's all handwritten and everything. It's kind of cool.
Now, you want to go get the one at the county too, the certificate of birth.
Yeah, I've got that one, and I've got my footprint also.
Okay. That's good. That gives you all three titles.
I can't wait till I understand what I'm holding and what I do with it.
Well, the reason I tell people to read the law of agency is you need to know the foundations. Because what is that certificate of live birth? Had one court already admit it's a state agency. If it's a state agency and it's their property, you need to know your relationship to it. Because why? If you end up going to probate court to get control of the name, you need to be able to articulate it in a way. You don't have to be perfect. You just got to be able to stand on your square, so to speak. You got to be able to speak to the judge in what he's going to understand. Zena, the footprint document is the document that was created at the hospital.
Yeah. Well, so the certificate, it just popped in my head and I lost it. So the certificate of live birth proves that I'm the agent for that entity that the state made.
Yes.
Okay.
You will never be the piece of paper. You can't be. The piece of paper didn't make you. And that's part of our problem is we've been running around thinking we're that piece of paper. You're not that piece of paper.
No, that piece of paper is a business.
Yep. The question isn't who's the owner of the business. Well, the state is for that, for the social. But you go get your TIN, you can be. I hope they hurry up and call me. I'm ready to get out of here. I'm picking up some paper, rolls of paper. See, me, I'm. Some people have a problem operating that entity. I look at it like this. I don't have a problem with it now that I'm figuring out what it is and what my relationship to it is. That's why I'm working on the paperwork I'm working on. Is, hey, if it's theirs, let it be theirs. Just make sure they know who I am in relation to it. I don't care about getting a big payout from the trust account like some people. They're after that big payout that I can take control of the trust and give me all that money. Forget that. Can't take it with you when you die.
Speak for yourself. I know your wife differs.
No, my wife wouldn't want that big payout either. She would actually rather have what we've got taken care of. What you doing, Scotty?
I am walking around the George R. Brown in my car on my lunch break.
By the way, yes, I don't know if it's your process or not, but somebody sent me some documents the other day on the reason they sent it to me was they have confirmed it twice and it got a medical bill discharged. But since it's got a certain somebody's information on it, I can't just put it out on blast.
Right.
But two different people got their hospital bill. Between the two of them, if memory serves me correct, we're talking about somewhere close to 11,000 total, just wiped out.
And that's through the lawful tender process?
It was not a W-4. It was not a W-4 process, none of that. They actually wrote some information down on a sticky note, wrote some information on the coupon, had a process server take it to them, and had 4 documents. That's all that was there was 4 documents. You'll have to call me after work, and I'll let you talk to.
Call me. I was just told by my rigger that I could possibly be here till midnight tonight. They were here from 8 a.m. to midnight last night.
Well, if that's the case, then call me your next free day.
You never know with these gigs. I'm actually working in the Apple booth today.
Tell them to
This
give
is
you one of those iPhones.
nah. I just want one of the participants because it's the Society of Women Engineers.
Oh, nice.
That's loud now.
What are you doing, cat? Running around a truck like you own the place?
Said just wrote some stuff on the paper, huh? It's called a negotiable instrument, I guess.
That is definitely the way it was done.
I didn't hear that. Could you repeat it?
Do what?
Whoever you were responding to, I didn't hear what they said.
Oh, they said it was a negotiable instrument, right? I said, yep, that was definitely how it was done.
Right. Okay.
Hey, so I have a question. Hey,
Okay, dog.
Cool Fox, can you mute? I think you're causing the. Okay, thank you. Echo. So I need some guidance here. I ended up volunteering. This is before I was awake. I ended up volunteering for this DNA research for ulcerative colitis and all these kind of IBD type issues, right? And so I went into the hospital, I gave my blood, all this kind of stuff. They did a full mock-up on me. And now they're using my DNA for stuff that now I understand is probably not good stuff. And they did send me a letter stating, like, do I want the results of my DNA, blah, blah, blah. Is there any way to send them a letter to cease and desist with my...
Do you have a copy of the original contract?
I don't know. Probably not.
Well, then you need to ask them for the original contract.
Okay.
And say, hey, I've lost my paperwork due to the cat ate it or whatever. And say, hey, can you send me a copy of the contract I agreed to? That way I've got it for my records. And since they've got your results, you might as well get them.
Get them. Yeah. Okay.
This, what you're discussing is part of the trust package binder that I have. And yes, I did pay for that. I bought it from a guru. And part of that process is to go to Ancestry.com, 23andMe, one of those. But you do a process where you capture your DNA and put them on notice that it's your freaking property. That they can't do anything with it. If they do, it's a violation. And, of course, there's a fee schedule attached. But there's
So
a
you don't have
process
to
to do
do
that.
the UCC thing? You don't have to do...
Say that again?
I say you don't have to do the UCC 1 or anything like that. You can just send them a letter, whatever letter you're talking about.
Well, it's a series of things because you're going to order the kit. You're going to get the kit. The kit's going to have a serial number, and then you put all that into your forms showing that, hey, when you do this test for this kit number, these results, that DNA sequence belongs to me, my property. It's not yours to sell, trade, barter, whatever.
Now, well, that's why I was saying go get the contract, because in the contract they will that you sign with them, it will tell you what their rights are and what your rights are. And if you have the right to resign at any time and they will destroy the property, then yeah, you need to execute that right.
Okay.
But if you don't have their contract, you don't know.
Right.
Yeah. You have to have the certificate of origin.
Now, their contract, you can place their contract into a trust, and that DNA, that's one of the things that, do you remember the Smoking Baby W4 seminar?
Yeah.
Which one?
Oh, never mind. Never mind. That's the 2.5-hour video. You haven't seen the 11.5-hour video.
Oh no.
Oh no, I've only seen the 4.5 hour.
Yeah, in the 11.5-hour video, after he does the W4 presentation, Derek Gonzalez comes on. 30, 45 minutes later, Smoking Baby pops back up, and he gets to talking about a legal book that come out of Japan. No, it wasn't a legal book. It was a scientific journal. And it was all the ways the government can identify you. And what he did was he did an electronic copyright on all the ways they could identify him and put it into a trust. Because why? You can't copyright it yourself and protect it, but the trust can for the beneficiaries. And the reason why his argument is because of the Hobby Lobby case. So that right there would help. Because remember, Hobby Lobby got sued over the medical debate with Obamacare and the abortion stuff. And the Supreme Court, the court sided with Hobby Lobby because why? Yes, Hobby Lobby does not have religious beliefs, but the shareholders, who are the beneficiaries, do. So Hobby Lobby can protect their interest. So it's the same principle.
Okay, I'll look into that.
Yeah, that video, if it's still on the W4 channel, it's over 11 hours long. So you'll come in about 3.5 hours and start listening from there, and then he'll start talking about it. And I'm glad you reminded me of that, because I wanted to go purchase that book, that journal. It's like $100.
Is that the journal you're talking about the scientific?
Yeah. It's not free. You can't find it out there for free. It's a freaking $100 scientific journal put out by some Japanese scientist guy. And it goes over people would be blown away of all the different ways they can identify you. I really am of the opinion, if you go back to COVID and standing 6 feet apart, they needed to do that to be able to get your heat signature. Because why? Why do you think they have special forces when they're out on a mission? They have to go in tandem 6 feet apart. In other words, they have to walk together no closer than 6 feet, because the satellite can't see them as individuals until they are at least 6 feet apart. Anything closer than that, it looks like one person.
Right. Yeah, I've seen the video about that.
Yeah, so I think COVID was really about stand 6 feet apart, as they needed to get everybody's heat signature.
Yep. Did you say it was Japanese or Chinese?
It's Japanese, but I don't know his name. Let me see.
Hey, Floyd.
See if I can...
Oh, sorry.
Go ahead.
I was just going to ask Floyd, are you still on here, Floyd? Okay, well, I'll ask you, Pastor. You may know. I know that you're not big into the fee schedules, but
Oh, no,
I'm just
I don't
curious.
have a problem with that.
Oh, okay. Well, I'm curious. I know, because I feel like, I've never learned how to do it, but I figured that I would do put it on the public record, or, put it in the paper for 30 days or something, and then have it recorded. Do I have to record it in each state, or just the state that I live in, or is it in a state that I intend to use it, or, how does that work, if you know?
No, what I'm not a fan of is the way it's being used. Okay.
that.
Um, John
Okay.
Eric Roca, he's in this group. If whenever he has to go to court, he sends a notice to the court. I don't know word for word exactly how he does it, but the basic premise is this. It says, look, my time is valuable. I will be glad to perform to your services, but since slavery is illegal under the Northwest Ordinance and my time is valuable, my fee is paid up front is blah, 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 and then my hourly rate is blah, 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 and send it to him.
Okay, so you're saying just do it that way instead of,
You can
posting a
put,
schedule.
yeah, because the government kind of frowns upon the phrase fee schedule, and it really does matter on the language used.
Well, I mean,
So
they post fee
if
schedules.
they do, but it depends on what you're doing it for and how you're doing it. Say, for example, if you're going to put on private plates and you've perfected title to the vehicle and you've got true ownership rights, which the average person does not, and then you notify the government that you are going to be exercising your right to travel, and if you trespass on that right, for me to perform any services because you want to remain in honor at all costs. See, when they give you an order, yes, I will follow your order. But since my time is valuable, this is my fee or this is my compensation. And I got John Smith. He actually says he sent him a letter and said, "Hey, well, for me to perform any services, it is a $50,000 retainer paid up front and $5,000 an hour thereafter." To me, that's a little on the extreme side because you kind of can't. You got to put reasonable numbers in there.
Yeah, you're never going to collect that.
Well, no, you might can collect that, but if you put in a fee schedule where you got to pay me $1 billion if you do this, they're just going to ignore you. That's not even reasonable.
Right.
You know what I'm saying?
Pastor, do you think it's reasonable that you work all week, 50 hours, and bust your ass and make $600 or $700, and then on your way home you get pulled over for a victimless crime and they charge you $500? I mean,
I never said that was reasonable, did I?
That's what I'm
No,
saying.
but I
Reasonable
said,
is determined by one's
but
perception
what
of what is reasonable and what's unreasonable. And I don't think it's unreasonable to charge them $50,000 to waste my fucking time.
I never said 50,000 was unreasonable, did I? No. I said that's probably up on the upper limits of the fee schedule. Because there is definitely not many people out there that are charging $5,000 an hour. You know what I'm saying? So, I mean, can you supply that? Yeah, I mean, shoot, what's that case out of Florida? It was like $1,000 a minute, I think, is what it come out to. That $23,000 for 19 minutes.
I thought the Supreme Court ruled that you could charge up to like $6,000 a minute.
No, it's not. It's not that much.
No.
It's a little over 1,000, like 1,000.
$1,000 and $1,000.
Yeah.
$1,086.
Oh, okay.
Now, if you wanted to, you could potentially try. Yeah, but that case was for false imprisonment. If you wanted to, that was in 1984. After inflation, what would that number be today? And when I checked the inflation calculator said today that'd be over $3,000 a minute.
That was Treservant, I believe.
Yeah, Treservant. Do you know
Yep.
that the Treservant case, he went back and requested more money on the attorney fees, and you cannot find that ruling on the attorney fees? You can only find the ruling that the attorney fees were granted, but you can't. Do what? Do what, Jesse? Jesse.
I think he dropped.
He fell off. Yeah.
Let's see here. I'll share the Trezevant case with you. Trezevant versus City of
Versus
Tampa.
Tampa, yeah. There you
Yeah. I went through Westlaw. They even scrubbed the other ruling from Westlaw.
go. Yeah, they arrested his civil liberty by arresting. That's right to be at civil liberty.
So
Some of the
yes, as a
stipulation,
pro se litigant, you can charge attorney fees.
yeah, you can charge attorney fees because, like for instance, if you go to trial in a case and then you actually like even child support and you lose, they can actually charge you for attorney fees and everybody that present. So yes, you can charge for your attorney fees. And you will get payment for it as well as long as you win the case.
Yep. If you win the case, yes, you can. But the other ruling that he tried to do on the ruling for the attorney fees, they've scrubbed that ruling from the internet. You can't even get it on Westlaw, and Westlaw typically don't hide nothing. But that one ruling on the attorney fees, it ain't even on there. They just scrubbed that one completely.
They don't want you to know how to be extorted.
No, they don't.
If they conceal it, they will scrub it. If it's something that they conceal, they will scrub it. They can scrub it. Like for instance, if you seal a case, you can scrub it. You only can get it down there when you go down there for disposition, and I guess nobody gonna go for that disposition.
Shoot, they scrubbed the one in what was it, in 1985 on the 16th Amendment wasn't properly ratified. I've got a picture of the memo from the IRS where the guy they charged for tax evasion in Indiana, they produced unequivocal evidence. In other words, they went back to all the states and got the ratification process on the 16th Amendment and produced it in court, and they beat the IRS on the fact that the 16th Amendment was not properly ratified. So that memo was floating around in a black and white document. So I went to Westlaw and said, let me see if I can find it. I didn't find it in the IRS decisions. I did find it in Illinois revenue rulings 12 years after the fact, and they had scrubbed it from the internet except for those Illinois revenue rulings that quoted it word for word.
So would a law book in Indiana, say in a law school library, have that case that you could find that?
Not likely, because that's one of those type of cases the government does not want you to ever get your hands on. Because why? They want everybody to continue to volunteer to give up their wealth.
Yeah, I know. You made
Not even with
me want to
a
run to
FOA.
Bloomington real quick to the law library and check it out.
It doesn't even give the name of the defendant. It gives the name of the U.S. attorney in the case. Give me a second here. I'll do this. Let me scroll through my TikTok because I did a video on it. There it is.
An echo. Is somebody's mic over?
It says on March 5th, 1985, a charge of tax evasion was filed in U.S. District Court in Indianapolis, Indiana by U.S. Attorney George Duncan. The charge was dismissed. The defense attorney, Lowell B. Craft of Huntsville, Alabama, presented irrefutable evidence that the 16th Amendment to the U.S. Constitution was never properly ratified. This amendment, which established the income tax, was signed into law despite serious defects. In reality, only two states ratified the amendment, and ratification requires 36 states to be valid. The effect of this is such that every tax paid into the Treasury since 1913 is due and refundable to every citizen and business. The official position of the service is, as it has always been, to aid and assist the citizens of the United States. We will not publish or advertise this finding, as a total immediate refund would cause a serious drain on the resources of the Treasury. For those citizens who become aware of this finding and apply for a total refund, expedite their refund documents as quickly and as quietly as possible. A simple 1040X form will suffice until a new form is designed and printed. Advise each of your managers that they are not to discuss this situation with anyone. There will be no written communication, and you are to destroy this memorandum. The Secretary of the Treasury assures me that there will be no reduction in the workforce, as this refunding activity will take a minimum of 5 years to complete. Further directions will be forwarded as the need arises. And it was signed by Roger Edgar Jr., Commissioner of the Internal Revenue. And
Can you
yes,
send me a copy of that?
I can tell you, I confirmed this. That was in Indianapolis. It was quoted word for word in 3 Illinois revenue rulings in 1997.
See why the Pope and all them washed their hands of corporations, because they went rogue. It's the wild west out here. All that matters is contract administration. Did you check yes? Did you check no? It's either or. And if you check yes, you better know why you check yes, because if you don't know the why, the path that you took, left or right, they are going to make a summary declaration of it because you don't know the path you're on.
Well, guess what else? Do you know you're not even supposed to be using government forms?
Because if you look up form, it's a skeleton. It can be animated and cabled. It's called cabling, any way that they choose within their construction. If I take that form out here and wipe my ass with it, they can't use it because I didn't submit it back to them. I didn't make application for a legal grant. But if I submit it back to them with their secret winks, societies, and handshakes, their third party fictitious plaintiffs, so to speak, they can use it for anything they want to use it for because their construction is interpretable within their construction. They don't have to answer to me.
Actually, no. It's either in publication 908 that I shared earlier, or it's in publication 901 that I just shared. Dee brought it to my attention. You're not even supposed to be using their government forms. You're supposed to be creating your own forms. And
I agree. I agree with that.
They even tell you.
Yes, you're supposed to create your own form, even your birth certificate. You're supposed to do all of that, but you use their form, so therefore you get tied to the contracts.
That's right. You're supposed to be using your own forms, and they even tell you there's a process to go to the OMB office to get those forms approved.
Without an OMB number on those forms, which most of those forms have OMB numbers, unless it's a local contract administration of the Office of Management and Budgeting, they're just hearsay to begin with. They're just an inducing offer to contract. The OMB number is what makes them fact in international law above that local contract administration.
Yeah, so you're supposed to create your own forms with all your information that you need to submit and send those forms in.
Hey, Pastor.
Yes.
So, can you send me kind of like what I would need to look for if I was in a law library for that court case with the IRS in Indiana?
I just shared the video.
Yeah, it's
Okay, I'll watch it because
It's
I
a
can't imagine
it's
a law school wouldn't have it.
that Indiana Law Library. I've been there. They were getting rid of the books when I was there.
At IU?
The one in Indianapolis.
No, I'm talking about IU School of Law here in Bloomington.
Now
Yeah,
Bloomington, I
Hannah,
haven't been to that one.
I
The
just
one
did
in
this, Hannah.
the one
Go
in
ahead.
Indianapolis, that law school in downtown Indianapolis. No, it was on the north side of Indianapolis. They were getting rid of all their books. They were going straight digital.
I just did this with the local library here that's outside of Bloomington that you're talking with, and I did it about a year ago. Went to get the Levine's commercial manual because it's one of the 4 books that I use, and they didn't have it, so they had to order it from the Bloomington Law Library, and they did that. And then when I got it, they kept bugging me to bring it back, and I wrote them a notice that, hey, I'm not done with it. When I'm done with it, I'll bring it back. But I had to order it from the Bloomington because they didn't have it. This is a 1947 manual that they got from that Bloomington library. And you can do that. You can request that through your local libraries because I'm not a librarian or a historian. They are. They
Yes.
Go
Now
ahead.
that brings up a good point there, Bobby, that you can actually go to your local law library and request law books, and they will get on their little system
Right.
and they'll send it to the law libraries around the state and see who's got it and have it sent to
Now,
your local law library.
Now, they may say that it's out of their budget to purchase these books and these kind of things because they're saying that because they think you're a legal customer. You're not making that request like that. You're making a request as a people through and if they don't do this, this is not only FCC violations, but it's also consumer protection violations because they're keeping the knowledge from you. They're arresting your development. It's the same thing all the time. So you ask them as a people that, hey, I'm making this request, and isn't your charter of this library a public service, and am I not of the public? I'm making a request as a people to be furnished with these things. Who is the guy I need to talk to make it happen? That's the way I do it with everything.
Pastor, there's no link. It's just a video for
Yes.
the tax.
Arresting my development. I love it.
I was trying to find the link because I want to make a copy of it.
Well, yeah, and that's why, because I wouldn't go through the library. I went through and got Black's Law Dictionary. I did the request for it. So I know how to do all that. I also know that if I go to IU, I can't check out books unless I'm a student, but I can go in and look at the books all I want to. So, because they're 20 minutes away from me, I would be interested in digging down and trying to find that case and get the written proof if we needed that at any time. Because I'm pretty sure they probably go
The
ahead.
only problem is you got to find the actual case. And all we know is, let's see. The problem is we don't know when. It says on March 5th, 1985, a charge of tax evasion was filed. This revenue ruling was put out April 4th, almost a month later. Okay. So that means there was a case filed on March 5th, 1985, and it was dismissed before April 4th. We know who the attorney that defended the case is, but then we know who the U.S. attorney is. That's it. So you'd have to go to the U.S. District Court and see if there's a way to get copies of all the court cases during that 1 month time span. Because if it was dismissed and they did not want it in the public, the only place you're probably going to be able to find it is at the U.S. District Court in Indianapolis. And that's only if they haven't scrubbed it.
And that's my point, Hannah. You said you know how to make the request, but they're still arresting your development by making you come there. We don't go there. We don't take those orders to go there. So if you want those things, or if you will those things, I hate to use the word want, you need to talk to the proper people who can copy and bind those for you and send them to you if you don't want to go there, if that makes sense.
Let's see here.
It makes perfect
97.
sense, but you have to understand that I'm a person that I want to see it for myself. I want to do the digging myself, and I want to lay eyes on it because I trust no one. That's just
Okay.
me being in a family of boys.
So you're a coal miner's daughter.
Pretty much they come to me for me to find them things. That's what I do. I find things.
Yeah, I feel you. I get it. We got to remember that they just declared a state of epidemic. So they're telling the public that they still have a state of emergency. And you can use that. It's called a major. Shoot, I just had it on the tip of my tongue. I'll remember it in a second. It's a French word, and that means that if someone has declared these things, to stay away from them, and you can make requests through tele from afar, and that's what the telephone,
Force.
television, and telegram is all about.
Are you talking about force majeure?
Exactly what I'm talking about. It's not a common thing that people talk about, but that's what it is. And we do that in a corps de combat manner, and a nose contendre. I don't think that's the right word, but Jesse used it earlier. Somebody used it. What Jesse did. We're not putting any claims of combat in there because we're not in competition with the other man. We're just requesting furnishings of their public holdings that they monopolize, so other men won't take them and burn them and abuse them. We don't need the original. We need the exact copy for our household economy, so to speak.
I haven't had a chance to verify it, but apparently Putin has declared martial law.
Oh boy.
Yeah, so if you look at the shell of the marring of man, okay, those two words together will tell you exactly what's happening in reality and why we should not be participating in the fiction, because the reality is the shelling of the marring of man.
Yeah, y'all better buckle up, because they're gonna put out some really hot. They're gonna start shooting some really hot candles in the near future.
And the reason gas, they're trying to tell you with gas consumption. If you look up the gas, that is the air. That is the colors air that the men are putting on in public. So if you look at the gas prices directly relate to the mind and the consciousness of the public in its entirety. People just miss the small stuff. It's the asing. The lower G is the asing of the king of the god of this earthly king, sovereignty. So if men are going to act like that, put on airs, gas out, expire, and make these wastes, they're going to pay for it through consumption.
Let's see here. I just went and pulled the revenue rulings from Illinois. Now, yeah, they're going to take this war. This war is going to be a hot war, and it's going to end up going nuclear.
Who was the judge on that court case?
Do not know. Okay, there's the 3 documents. That's the ones out of Illinois. Let's see. So now, if you scroll to the first one, if you go to the bottom of page 3, second paragraph from the bottom, it says, please review the final determination of your position that on March 5th, 1985, a charge of tax evasion was filed in the U.S. District Court. It quotes it word for word. And each of these are out of the Department of Revenue for the state of Illinois. And when I saw that, I had to go find it and see if it was any kind of truth to it. But yeah, I would like to find that case, but I can't find it nowhere. I've looked on Westlaw. I've looked up who let's see, U.S. Attorney George Duncan. I've looked him up, and can't find anything. So let's try it again. Let's see. Browse content.
So is that 3 things that you're sending? These 3 different things or 3 the same thing?
Yeah. No, there's supposed to be 3 different.
Okay.
Attorneys and judges. First and last name. Paste. George Duncan. United Kingdom. Let's see. George H. Duncan, George Gary, George E., George R. Well, now I need to find out this. U.S. Attorney paste. George Duncan. George H. Duncan. No. Hmm.
All right, I'm gonna drop 2 codes that I found the other day inside of the chat.
Yeah, I don't know what George Duncan's name is. So I've got George H. Duncan, and I got another one. But that's in New York. Illinois, John Marshall is constituted. So I need now. Let's see. Well, this one's out of Illinois. Let's see. It's not letting me see the database. Let's see here. Reference. Now, the other problem is, being that the case was dismissed right after it was filed, it may not even exist because there wasn't necessarily a ruling per se. In other words, the court just dismissed it. It went away.
Yeah, but there would have to be a record of the initial filing.
You would think so. That is true. And I've even went on Pacer and tried to find it. And Pacer typically has everything. Well, that one definitely ain't it. The oldest one there is in 1990. So it ain't that one. Expert witness, expert witness. London, Oregon, New Mexico, Atlanta. I don't know that it lists U.S. attorneys. I figured it would. Yeah, they're not allowed to give loans by their own stock. That I'm aware of. That's why I say banks do not loan money. They buy promissory notes. And I actually run into a lady on TikTok that used to work on the private side of the bank. And it always blew her away how the bank would have so much money. I said, that's how, because I explained it to her. So, anybody else
Well,
got any questions or anything? Do what, Hannah?
that gives me something to dig into. If I find anything, I'll send it to you.
Well, that'd be freaking awesome. But I'm wondering if this is like one of those cases like the coffee bean case. Are you familiar with that one? The
Yeah.
coffee bean case, that court, it never got appealed, so it never got into the publications. It was only at the low-level court. And that court ruling became famous, and they only produced 125 copies of that case. After that, the court was not publishing anymore. That's why that coffee bean case is so hard to find, and you can only find a part of the transcripts. But it is a true case because my buddy Mark up in Minnesota has paid a traffic ticket using rice.
I paid a traffic ticket by filing for indecency and putting zeros on there.
Hey, that's the thing. People don't realize there are a million ways to settle debts. And Federal Reserve notes are just one of the many ways.
Pastor, I tell you what happened at the courthouse in regards to paying? I didn't tell you that.
Yeah, you did. Did you happen to record anything?
No. There was no recording it. It was more of a private agreement type thing than it was. He was already worried about me recording him when he called me on the phone. He asked me,
Oh, okay.
I heard a beeping noise. Are you recording? So, I was like, no, Your Honor, I'm not recording. So I didn't want to, go in there and try to step on anybody's toes or anything. It wasn't like that.
That I understand.
But the lady basically said, well, how are you going to pay for this? It's 200 and something for this one and 300 something for this one. And I said, the paperwork already says that I can't pay because there's no money to pay. So that's how I got around having to say that there's no real way to pay money or debt with a debt, right? So I used the proper affidavit to express that principle without having to reveal that there was no money. And I said, well, what you can do is, you can bring forth the court order, and I'd be more than happy to sign the back for you, pay, endorse it to whoever you need me to, or I can appoint the judge was sitting right there. I said, I can appoint you judge as fiduciary, and I can turn over this birth certificate. But those are the only two valuable things I have of consideration, because on my pauper's affidavit or on the application, I put 0, 0, 0, 0, 0, no income, no house, no residency, which I don't have those things. And then he had me sign down at the bottom. He said, well, go ahead and put on there what you do. So I put that I'm in private business, and I mind my business, and I do trust and estates for work for donations only. And he said, okay. And then he took it and he goes, he said, we're done here. And I was like, what?
Yeah,
I
all
said,
he needed you to do was sign off on it so he can go to the treasury and
that's
get the
correct.
money.
That's all he needed me to do. He just wanted me to come in there, appoint him and let him be fiduciary and do his job. Because he
Yep,
told me
that's
on the
it.
phone, he said, there is no way in hell I'm letting you come in here and file any paperwork after looking at what you sent me. That's what he told me.
What
I
did
was
you
like,
send him?
I sent him.
I love it. I love it.
He goes, I promise you, you will not be filing anything in my courtroom. I was like,
What
so
did you send him?
well, I sent the original ticket back to him within 72 hours per TILA, right? But the problem is that what I should have never did is I shouldn't have put no jurisdiction on the ticket, right? I
Yeah.
shouldn't have put that, okay? But that's okay because it got me in there and it got me to talk to him, and have a one-on-one rapport. So I just rescinded it with 72 hours, and I sent back proof of service with 3 witnesses, right? And then I sent that back federal postal carrier mail, right? And then the second time when he sent back the summons, I sent it back return receipt signature confirmation with 3 witnesses, and he never returned that. Like, he wouldn't let me complete my due process. And inside of there, I also sent up a little disclaimer from the executive office, right, making the complaint coming down from Casa de Henley. And I basically wrote it as the executor making a complaint about what was going on and how they were trespassing on private property. And then I sent the 3 notices that I had, because you got to remember, I sent out about 38 different notices in triplicate to the U.S. Department or to the Department of Public Safety, to every sheriff within, like 10 county radius, all the little cities that I travel to, to everybody and their mama. I got them under contract.
Yeah.
And I went in and I got my paperwork and I was going through it and I was like, man, I know I got the sheriff of Hood County in here somewhere. And then I found it and I was like, oh, there it is. I said, where's my certificate of service? I put that in there with it from the original packet that I sent. And I put it all in there and sent it to him. He wasn't trying to hear none of it. He called me on the phone and he told me on the phone, he said, it's not customary that we call people who have citations before they have entered into a plea, but I've made an exception for you, Mr. Henley. That's what he said. I was like, okay. But I made sure to tell him that my name was not Mr. Henley when he called me. That was about the only thing I got to say. He said my name was Mr. Henley. He referred to me as being a sovereign citizen. So I said, my name is not Mr. Henley. I would appreciate it if you would call me Jesse. And then he said a few things, and then he went straight into his sovereign citizen bit. And then I said, I'm not a sovereign citizen, oxymoron. And then I didn't get to say anything else, Pastor, all up until the point to where he said, well, I'm the justice of the peace for the common man. And that's when I interjected again. And I said, I have a question, Your Honor. I said, you said for the common man, does that mean that your courtroom is common law? He didn't know what to say. You know what I'm saying? And he kind of twisted around and he's like, well, I'm the justice of the peace for the common man. I said, so is your courtroom common law, or does it operate under Article 1, Act Section 3? And then he goes, sovereign citizens think they know the 14th Amendment. So he went back to me challenging the jurisdiction to evade my question. But when he sent me a reply in the mail, this is the best part. This is how I knew that the question that I posed to him struck a chord with him. Because in the letter he sent, he put in quotes, he was saying that I wasn't subject to anything other than common law courts and no tribunals, or whatever his quote was. And then he said,
Article 1s.
Yeah. Then he said that the justice of the peace, okay, quote, is the common law. I was like, oh, so you're acknowledging
he was basically telling me that his courtroom is not necessarily true common law, but at the very last sentence he put Article 3, and he said that he extends courts of equity in any treaties. His job is to protect anyone who's entered into a treaty with the United States, and he also deals with equity. Well, my trust is a treaty with the United States, and I was using equity. Because that was originally,
Hey,
except
Smoking Baby told me one time, he said, what are you trying to do? You're trying to make peace with the United States. So he said what he did was he started studying peace treaties, looking at different countries' peace treaties. And he said, why not write your own peace treaty and send it to the government?
right. Or you can just take the amnesty oath. You take the same oath that General Lee took, and you send it to the president, or whoever you need to send it to. I'm not necessarily down to take an oath, to the United States, but if they're going to extend the amnesty and leave you the fuck alone, excuse my language, but that's a good thing too, right? So you
I think so. That's what I say. They always leave you a way out if you just read.
He also told me,
Congratulations,
Pastor,
Jeff.
that he told me that he couldn't protect me while I was out on the road, but he told me that he could protect me when he was in his courtroom. And I was like, cool. So basically he was saying, let them write you a ticket, Jesse. When you come in here, we'll get rid of them.
Well,
Right.
otherwise, that goes back to the law of agency. He's a special agent. He can only do things in his purview of authority.
Secret agent, man. Secret.
Yep. But he did make it very clear to me. He told me two things that really stood out to me. He told me his sovereign citizen story, where this guy had leaned up his house and his cars and his wife and everything. He made it very adamantly clear that this guy went to prison and that unfortunately he's dead now. And I was like, oh,
Well, that's a gem right there. He's telling you that, just like Pastor just said, you have to separate. You have to know when a man's talking to you in and of agency and assumes that you are participating in some sort of agency, and when the man's not having that conversation with you.
Right,
It's
no,
very deadly.
absolutely.
It's very terminal.
We were out in the hallway, and then I went on to tell him, after he said that to me, I knew exactly what I needed to say. I said, well, Your Honor, I said, I didn't do all this due diligence to try to sue anybody. I do not have any intention of suing any war. I'm not at war with the United States, and I do not want to go to war with anyone else. And then I looked at him and I said, and we both know, Your Honor, that you can't argue the 14th Amendment. And he smiled. And I said, and I apologize for causing any controversy. And he said, no, Jesse, there is no controversy. And then I got to say to him, I said, well, Your Honor, I was going to say that you're right, the 14th Amendment, we can't argue that, but the 13th Amendment comes before the 14th Amendment. And it says in there, no voluntary servitude. And he's just kind of laughed, and then we just went on about the conversation. So
the suing and the suability is comes from assisting, being an assistant. So if you're going to subject yourself through voluntary servitude to be assistant for someone else, that's directly being surety for someone else, and you're usable. So if you,
that I'm claiming suretyship and that I'm challenging whether or not they have the ability to force me into compelled performance, which basically by doing that says that they have the ability to do it. It contradicts itself. It's double
and you're falling out of honor with yourself because you're making yourself your own competition, and we're not in a competition with any other man. Those rules and regulations of legality are the dark matter, they're antimatter that men put out there, and they make themselves competition by doing that.
Well, see, I wouldn't sue them. I would my trust would be sending them a bill, because that's basically who's got them under contract is the trust, not me, right? It's the trust. So if they violate the terms of the trust, then the trust reserves the right to be able to bill them the same way they're trying to charge me to do business with my trust. I mean, I'm just operating business the same way that they operate business. They just don't like it.
Yeah, that's one thing about when you got your trust structure set up right. The trust does have the authority to sue the state because they're on the same foundation. They're on the same
we call
footing.
It suing, though? I mean, is a bill for services considered to be suing?
I thought that they were kind of, I mean, similar, but not really the same thing.
No, what's the Declaration of Independence, Constitution, and Bill of Rights? It's a trust indenture.
Right. So I guess it can be sue or be sued. So I guess that's what agency is all about.
Congratulations, Jesse. Very good story. Very good
Yay,
progress.
I'm getting loaded finally.
It's definitely
Good job, brother. Go ahead. I'm sorry.
Yeah. So, sorry, I got a phone call. The shipper said they're going to load me. So, no, but what I was asking you is, what is the Declaration of Independence, Constitution, and Bill of Rights? It's a trust indenture. Okay? It's a trust. So when you establish your trust, that trust is on the same level as the state.
Sure, because they're both the states. The state of is actually on an international level, and the trust would be too if it's done right. But the problem that I see with the trust is, most of the time it ain't done right, and every attorney I've ever asked about a trust said that they're all pierceable. The veil can be pierced of the trust.
Well,
because go ahead.
The way it gets pierced is when you got people that don't know how to manage it.
I agree with that, because they overstep the bound. They literally go outside the job description of the trust, and they get involved with it in a way of engagement, right?
Yeah, you got a lot of people in this movement that thinks if I do a trust, that trust is in the private. I don't have to do this. I don't have to do that. Like the whole thing about I don't have to file. When you do things in a trust, there are certain rules that applies. Now, does that mean you might have to pay taxes? Maybe. If you actually had a taxable event under that trust, then yeah. But it doesn't mean you don't have to file. You got to learn how to manage the trust so that way you don't trespass on the rights of the state.
Yeah, you have to learn how to jump in and off those timelines. That's man aging, okay, of that trust, and you got to know what those terms are for those timelines.
Yeah.
So
Legality is based on terminologies of terminal figure. They're specific when they have those definitions, and those definitions are specific to them, right? That's why they're terms.
I mean, a trust does put the property into the private to a degree. And the indenture is private. The indenture establishes the rules the trustees have to follow. But the trust in and of itself and the trustees are not private.
Well, can we say the trust is then put, because the trust is going by universal law, common law, if you will. So is the trust is in the private sector of the public, even though the men are still trying to stay private and be arm's length from the trust. The trust still has to be of the public, so it's got to be in private sector of the public, right?
It's your public-facing entity to operate in commerce.
Sure. I agree.
Cool
What about
Fox,
revoking?
you're
What about revoking?
echoing again.
What about
So
revocation of your elect? Go ahead.
I have a question regarding. Dadgummit, now I muted myself. Regarding, like, if you don't have any property and you don't have anything that quote can be taxed except for, say, your labor, you don't have to file, correct?
Well, you don't really have to file as a man or woman anyway, because there's nothing in the Title 26 that says you have to file.
Think of it like this, okay? Just because you're doing some accounting doesn't mean that you're necessarily doing taxes. Everyone has to be accountable. So at the end of the day, you just have to make sure your books are balanced and that you have done your due diligence and you have done your paperwork. Paying taxes means that you're actually paying money out, but everybody has to do accounting. There's no way of getting around that. So don't equate paying taxes with doing accounting, because they're really two separate things, but they are one and the same at the same time.
Yeah, that is a true statement. And that is ultimately what's getting people in trouble is we're not doing our accounting right.
So it's where you're doing the accounting at. It's the where, like Eric mentioned earlier. Yeah, I'm doing my accounting in my household economy and not for the profiting of the specific pecuniary profiting of the benefits of the principality that they assume I am. So if I'm doing my accounting at home and doing what I need to do, that's a whole different story than volunteering and gifting that time away to do someone else accounting as their secretary, if that makes sense.
Well, you also got the whole thing of profit or gain. A lot of people don't understand what profit or gain is.
But what about the revocation of the election?
How can you revoke the election for the trust? You have no authority over the trust.
You said set up your own trust, so that's what I was debating on, not actually out of trust. I'm talking about your own trust.
Well,
you your own trust and you revoke the election.
You can't revoke what you never elected into.
Right. So if you never elected into it, then how do you have to pay tax out of it?
Because your actions will determine whether you're elected. Give you an example.
Goes back to combat.
My dad, learning this stuff because I share with him what I learned. Okay. He filed taxes one year. He voluntarily sent him $10,700. And when he did his tax return, he got back $10,700. He not only got back that, he got back $10,756. Now, the $56 was for interest. What was the interest? Okay. Well, what did he get last year? He got a W-9 from the United States. Okay. And it was for $56. No, at $10.99. So guess what? Because he got money from the United States, that's a taxable event. Okay, so now what did he have to file taxes on? He had to report the $56, not the rest of the money that he earned throughout the year. Did he elect into something? No. He received money from the United States, which is a taxable event.
Okay, so if I took out money out of my 401k to pay out some bills, would that be a taxable event?
You take it out before it matures.
Yes, but the federal government already took its 40%.
Yeah, but aren't there penalties that are attached to that when you take it out before?
No, it was like this one-time fee type thing. You could take out a certain amount of money.
Okay, then it shouldn't be taxed.
Well, they charged you to take out that fee, though. That is the tax. Right?
Yeah,
the
that is the tax.
When you entered into the contract for the 401k, there were certain terms that you agreed to in regards to how long you would let your money sit in there. If you took it out, what the fines and the penalties would be. So that is the tax in essence.
Okay. So I was able to forego having state take out any tax, but they could not override the federal tax that was hitting it. So
I'm thinking what they did was that the clause that says if you take this money out before the the agreed to time, that it would be considered earned income, so that they could be taxed.
Correct.
Well, here's the other thing you don't know. Most employers match you dollar for dollar, right?
Yes.
Well, the question is did the employer's dollar get taxed?
Probably not.
Probably not.
I bet you they got a tax write-off for it.
That's right. So there might be a tax on that part of it.
Can't you just file the
There are few
9A on it
codes.
before they do? Because that's basically what they're going to do. They're going to file an A and a B on you.
There are few codes I've been reading. One of them I came upon that said the state cannot give you interest on a income tax. And the other one, I think it was, I forgot. I don't want to say it because I forgot word for word and I don't remember the numbers. But the state cannot take interest on your income tax. I mean, whenever you file and they say, for instance, you owe and they try to put interest on it, they cannot put interest on it.
Well, Dad didn't owe. Dad just voluntarily basically loaned him the money. He put all his business into the trust and stopped operating the way he did. Okay. So what did he do? He voluntarily sent him a check. Well, since he didn't owe the money and the United States used the money of the trust, guess what? That's where the interest comes in. Because it was trust property.
How about we start electing to get paid in United States currency instead of Federal Reserve notes?
Because Federal Reserve notes is a United States currency.
No. It's about, yes, they are the same, but what makes the difference between the two is how you elect to use them.
No.
Yes,
Go read the congressional record.
That's what he was saying. He said that it's all about election, that you can go into your bank if you have $300 in the bank, and you can go into the bank and request to get paid in U.S. currency, which means money straight off the printing press that is not, it's interest free, right? But you, as the individual banker, have to keep account of all the serial numbers on there because that money's value is different than the Federal Reserve note's value. I yield.
See, I've got a chute on each side instead of down the middle.
When you talk to Dee again, talk to her about it. Ask her about it, Pastor. See what she says.
What?
She was saying that it's what changes the currency is how you elect to use it.
Well, that part I don't know about. All I know is what the congressional record says, that they didn't get rid of gold. They didn't get rid of, they just redefined what gold was and then demanded you, and then changed it to where you can't demand payment in any certain species of gold. That's the reason why there are so many ways to tender payment.
Currency is nothing but a unit of measurement.
That's right.
That is.
That's right.
It all goes back to the election part. How are you electing something to work for you or against you?
Well, define what you mean by election.
If I'm going to do a revocation of election, then I elected to participate in something a certain way, right?
No,
So,
define what you mean by election,
I
because
just did. I'm electing to do something a certain way. So I'm electing to do it in a different manner than the way that I'm accustomed to doing.
yeah,
It's
but
like the opposite
that
of when
doesn't
you elect to do
explain.
something is revocation of election. You're doing the opposite of it. So what I'm saying
Yes.
to you is that you're not letting me finish, Pastor. I'm trying to answer your question, okay?
Okay.
What I was told, and I want you to go and talk to Dee about it so that you can have the conversation because she can explain it a little bit better than me. She was saying that there's a difference between the U.S. currency and Federal Reserve notes. And she said that they are one and the same at the end of the day, but it's about how you elect to go about using them. And that you can go up to the bank with an affidavit and something else with some type of banking law, forget what it was, and that you can elect to have the $300 taken and paid to you in U.S. currency, which is fractionalized. For every $1, it's worth 100. So you would get real money that has no interest rate attached to it, so that it's not adding to the debt. But you would be accountable as an individual banker of keeping track of that money, because it's worth more than the normal money because of the way that you elected to take it out from the Federal Reserve and to use it and put it into circulation.
That's 12 USC 411. 12 USC 411 redeemed for lawful money. David Merrill speaks to that.
You don't
Because
use
it's a fee.
You do not use 12.411. You use 12.412. Nobody's talking about that, but Eon, me, and just a couple other people. 12.412 is what you're supposed to be using, because what is the note? The note is the collateralized security for the money. And yes, that gets into the private banking that Dee's talking about.
And informed me last night that 411 has been removed, and they just did that recently.
Well, 12.411, we're not even supposed to be using it.
Yeah, well, she just found it odd that they removed 411 like within the last 3 weeks.
I will confirm that. Let me see.
Yeah. I mean, you can still find it in some places like Cornell Law, but she was telling me officially they've removed it. And part of that is due to the RV or NSR, or whatever you want to label it, currency revaluation, basically.
Let's see. Note amended. There's a 2021 House Resolution 4741 proposed action. But no, 12.411 is still there.
We are.
It is still there. But 12 USC 412 is what we should be using. Because this is the application for notes and collateral required. Now, let me see here. Oh, come on. Hurry up and load it. There we go. It says any Federal Reserve Bank may make application to the local Federal Reserve agent for such amount of the Federal Reserve notes herein before provided for as it may require. Such application shall be accompanied with a tender to the local Federal Reserve agent of collateral in amount equal to the sum of the Federal Reserve notes thus applied for and issued pursuant to such application. The collateral security, which is what? The note. The collateral security thus offered shall be notes, drafts, bills of exchange, or acceptances acquired under Section 92, 342 to 348, 349 to 352, 361, 372, or 373 of this title, or bills of exchange endorsed by a member bank of any Federal Reserve district. And it goes on and on and on. That's what we're supposed to be using. But that also gets into why you need to do your private banking resolution and go down to your local bank and set that up. Cat, I'm going to beat your hind end. Message tearing up my paper towels.
Are there instructions on how to go about setting up a private banking account and how much money you need to do that?
Who said you needed money?
Oh, nobody.
Don't you already have negotiable instruments in your possession called a birth certificate and a social security card?
Oh, okay. I didn't know that I could use that since it's not.
Yeah, put them in a trust.
You also can make your own.
See, the Federal Reserve Bank's a private bank. They make their own money, right?
Right.
Don't you have the same rights they do?
100%.
When you go down and get a mortgage,
That's what a negotiable instrument is.
when you go down and get a mortgage, what are you actually doing?
Producing money from my signature.
Do you know that one
Creating
thing
money.
that Congress has never did? They've never defined the denominations. If you go read the congressional record, I've shared it, of March 9th, 1933, they just used the same language that's in the Banking Relief Act in the congressional record. The obligations are as securities and gold that are deposited with the Federal Reserve agent. Who is the Federal Reserve agent? That's the local bank you go to that is a member bank of the Federal Reserve. When you issued the note at the mortgage table, that closing table, it don't matter. You can take and go to grandma's house and sit at the kitchen table. But for the time being of that mortgage, that closing table is a financial institution. You are sitting down as a private banker issuing money in the denomination that is written on the note.
That leads me to ask another question. Is the signature attached to the birth certificate or separate from the birth certificate, or is it attached to the Social Security? Like, when you sign your signature on a promissory note, don't they take your birth certificate and then sell it on the open market? Or am I wrong in that belief?
No, they take that security you issued that you attach the social to, because why? You're the agent of the trust.
Right.
That security is how they make the trust profitable as the agent. They take it and send it to the Treasury, and what do? Exactly what it says in 12 U.S.C. 412. And they deposit it with the bank, and it gets exchanged for what? Federal Reserve notes or book entry credits.
Okay.
Me and Eon's been talking a lot lately, and it's one thing he said is, he said the Federal Reserve Act is not what you need to read. He said what you need to read is the Banking Relief Act. The Banking Relief Act was actually passed into law. That's the contract. That's the contract with the people. And then off of the Banking Relief Act, everything else stems from that point where we get the Securities and Exchange Act in 34. And then in 35, we get the Social Security Act. And in 39, we get the Trust Indenture Act of 1939. And in 1945, they make an amendment to the Banking Relief Act. Actually, there's a list of acts he gave me. Let me see. Don't ask me the exact dates of these acts, but it said the Banking Act of 1862, 1864, 1913, 1919, 1933, 34, 35, 39, and 45.
So is it, so the understanding is that they're having an emergency banking problem because they are still trying to vendor close the bankruptcy of that constitutional republic, and people keep making submissions to it and keep swelling that bankruptcy so it can never be resolved.
I'm of the opinion the reason they can't settle the bankruptcy is because we're not giving them the information they need to balance the books. Think about it.
Yeah.
You've got a social security card that you run around in your back pocket. Now, I'm not saying you per se, but the average person. And you are creating public debt, signing the name of the trust and the social, but you're not reporting it to the Treasury, right? So the Treasury can balance the books for that account.
Right. Making submission and application that still has to be dealt with and securitized, but it takes another man to finish it up because we're not doing it right on its face. The par still has to be dealt with.
Correct.
Pastor, do you mind if I could get that list that you just read?
I just posted it.
All right.
But we're doing it in per, and they still have to consider the par, and those two are just simply conflicting nature as per the applicable submission from the get-go.
Well, you also got to go back to obligations of the United States, and you got to go back to HJR 192, right? Okay, in the congressional record, it says what? The new money is issued in exchange for what? Government obligations. Well, okay, so they issue the bank new money, and they say, okay, we give government obligations, but they can't take care of their obligations because we're not saying, hey, trustees, we gave this much credit to John Q. Bank down here, or we gave this much credit to the cell phone company, or to the power company, or this as the agent for the trust. So that means what? They can't settle the books because the books have to zero out. They can't zero out the books if we're not telling them what we're doing. And then we end up abandoning all that estate because we're not doing it, and we are making the bankers sub-agents for the trust. That's why they go and create all these other accounts in that name. And then since we abandon those accounts, they turn around and file a 1099-A and capture those abandoned accounts.
So I believe that's why they stuck with the Admiral Maritime thing for the prize and booty of that abandonment, because they knew most men weren't going to have that comprehension to do it the legal way, and they're just it's of that wants and desires of that minority mind, so to speak.
Well, it's not that they stuck with it. It was already in the Constitution. Article 1, Admiralty jurisdiction is actually, there's two sides of Admiralty jurisdiction. You got Admiralty law and maritime law, which are all contracts in commerce.
Sure.
And who gets to regulate commerce? Article 1, Section 8, Clause 3.
Okay, yeah, I get that.
So it's always been there. It's not that they stuck with it. There's 3 jurisdictions in the Constitution: Admiralty, equity, and common law. But we concentrate on one or the other and never put the whole picture together. I think to me, the way I look at it is it's a symbiotic relationship. If God or the creator or whatever you believe in gave us this country then we have a responsibility to do our part to take care of it. We can't point the finger at government and say, do it all.
Yeah, I can see that. I can see it could be symbiotic, and it can be symbiotic if we stick with the if well, I guess I'll say it this way: if I can stick with it and stay out of the usury side of it. Does that make sense?
Yeah. Well, see, you go back to 26 USC 83. What does it say in 26 USC 83? That compensation for services are not taxable. That is not considered profit or gain.
Right. Exactly.
Okay. So when you go work a job and you get a contract where you have agreed upon 15, 20, 25, 30 bucks an hour, that's your compensation for services. But let's say, for example, you do a contract with me and it's $1,000, and I say, you did a great job, but I'm so happy I give you 12. Well, the profit or gain was the $200. That was something outside the scope of the contract, and the profit or gain, that $200, is actually taxable.
And that's the very slippery slope that I always talk about in that trust. If they make those inducing offers and you fall for that sucker bet, so to speak, because you want that extra, that goes to the supra, infra, and what is it? Supra, infra. There's a third one I can't think of it, but those three prefixes are very powerful, and that goes directly relates to what you're saying there at that inducement.
Yeah. Now, on the other hand, if I say I give you your $1,000 and then I turn around and say $200 donation, then that donation is not taxable.
Absolutely.
But when you tie anything to the trust, people have the misconception of thinking that's their name, and it's not. It's you are using the state's trust, and since you're using their property, you need to report to the principals how you're using it. So the intent of Congress, honestly, they wanted the currency to flow. And they gave you tax forms to file at the end of the year. And if you did them right, you wouldn't be liable. But everybody's like, well, I don't want to read this stuff. I don't want to know this stuff. So they don't do it right. And then they wonder why they voluntarily went into submission and getting taxed. Well, why does the rich not pay their fair share of taxes? Well, you keep leaving them a way out because why? You're not reporting to the government who's using the credit of the trust. Because they already told you everything's prepaid, SJR 192. Yes, they repealed it, but they repassed it in immediately the very next act. The two most powerful parts of the Constitution, Article 1, Section 8, Clause 3, and Article 1, Section 10. Learn how to contract properly, and all your commercial affairs will fall in place.